Welcome back to the deep dive. We're continuing our journey through the MPP, the Manual of Patent Examining Procedure. Today we're tackling Chapter 1400, Correction of Patents, and specifically we're zeroing in on Section 1490, Disclaimers.
Right. So our goal today is to really unpack how, and maybe more importantly, why, a patent owner might formally give up certain legal rights. It sounds a bit counterintuitive, doesn't it? Giving something up. But often it's a really strategic legal move, and it's all governed by some pretty strict rules.
Okay, yeah, let's unpack that because disclaimer definitely sounds like admitting defeat or maybe throwing in the towel, but you're saying it's often strategic. So what's the basic idea here?
Well, fundamentally, it's a formal statement. The patent owner goes on record saying they relinquish specific rights in a patent or even an application, the aim. Usually clarity, consistency, maybe salvaging enforceability. It's about cleaning things up, legally speaking.
Okay, cleaning things up. And the MPP breaks this down into two main types, right? Let's start with the first one. Statutory disclaimers. What exactly is being given up here?
Yeah, so with a statutory disclaimer, you're talking about relinquishing one or more complete claims of an already issued patent, not parts of claims, the whole thing. And the why is usually because the patent owner has come to realize, maybe through litigation or finding some prior art, that certain claims are, frankly, invalid or way too broad.
Ah, okay. Like the example in the source material, right? Say you have a patent with 10 claims, and maybe claim number 5 gets knocked out in court as invalid.
Exactly. Instead of potentially losing the whole patent, the owner can file a statutory disclaimer for just claim 5.
And the other 9 claims, they remain intact.
That's the idea. They remain enforceable, assuming they're valid, of course. It's like surgically removing the problematic part to save the rest.
That makes sense. It sounds like a quick way to address a known problem without going through, say, a whole reissue process.
Precisely. It's generally faster and less involved than reissue or reexamination. It's basically saying, okay, we concede on this specific claim. No arguments, just removal.
Got it. And you emphasize complete claims, so no tweaking allowed.
Correct. That's a key limitation. You can't use a statutory disclaimer to, like, rewrite a phrase or fix a typo within a claim. It's all or nothing for that claim. If you need to edit the language, you're looking at other procedures.
Okay, that's clear. So that moves us to the second type, which sounds maybe a bit more complex. Terminal disclaimers. This shifts the focus from the claims themselves to the patent's lifespan.
That's right. With terminal disclaimers, we're not talking about the scope of the claims, but the duration of the patent right. It addresses the entire term, or more often just a portion off the end, the terminal part of the patent's term. Its main job, really, is to overcome double patenting rejections, specifically the non-statutory kind.
Non-statutory double patenting. Okay, refresh my memory on that.
Sure. It's a judicially created doctrine. Basically, it stops someone from getting multiple patents on inventions that are just obvious variations of each other, because that could unfairly extend their monopoly.
Right, extending the exclusivity period longer than the statute allows for one invention. So the terminal disclaimer is the fix.
It's the common fix, yeah.
Yeah.
Let's say you, the applicant, have two related applications. Maybe one's a continuation of the other. The examiner might say the claims in the second one are just obvious variations of the first.
Okay.
To get that second patent allowed, you file a terminal disclaimer. This essentially promises the USPTO that the second patent will expire no later than the first one. It cuts off that potential term extension.
So you synchronize the expiration dates. That sounds straightforward enough. But there's a catch, isn't there? Something about common ownership.
Ah, yes. The big catch. This is where it gets really critical from a long-term strategy perspective. The terminal disclaimer isn't just about the date. It must include a provision stating that the patent subject to the disclaimer will be enforceable only for the time period during which it's commonly owned with the other patent or application that caused the rejection.
Commonly owned, meaning the same entity has to own both patents.
Exactly, continuously. So think about it. You have patent A and patent B linked by a terminal disclaimer. 5 years later, you decide to sell patent B. If the buyer doesn't also buy patent A, patent B instantly becomes unenforceable in their hands. Poof.
Wow. So it really ties those assets together. That sounds like it could seriously complicate future deals, like licensing or selling off parts of a portfolio.
It absolutely does. It's a major constraint. Companies have to track this common ownership meticulously. It can influence M&A activity, joint ventures. Basically, any plan to split up those linked assets becomes problematic. That disclaimer filed years ago suddenly dictates business strategy today.
That's a huge implication. It seems like a heavy price for overcoming that initial rejection.
It is the price. The courts see it as the necessary trade-off for allowing the second patent in the first place. You get the patent, but with this string attached permanently.
Okay, really important point. Now, just to be super clear on the double patenting types,
Yeah.
you said terminal disclaimers fix the non-statutory or obviousness type. What about the other kinds, statutory double patenting?
No, absolutely not. A terminal disclaimer is useless against a statutory or, same invention, double patenting rejection under 35 U.S.C. 101. Because if the claims are truly identical, covering the exact same invention, the issue isn't just term extension. It's that you fundamentally can't get two patents on the same thing, period. A disclaimer can't fix that. You'd need to cancel claims or amend them.
Got it. So terminal disclaimers are powerful for the obviousness type, but they don't solve the same invention problem.
Correct.
All right, let's shift to the nuts and bolts, filing these things. Given how significant they are giving up claims or term, how does the USPTO handle the paperwork?
Well, they have pretty clear procedural requirements. The disclaimer needs to be properly drafted, signed by the right person, and recorded. Authorized signers are typically the patent owner, the applicant, if it's an application, or the registered attorney or agent.
And what info needs to be in it?
Key things. It has to clearly identify the patent or application number. It has to state exactly what's being disclaimed, which full claims, or the specific terminal part of the term. And crucially, it needs to state the ownership interest of the person signing. Like, do they own the whole patent or just a share?
And I know the USPTO is pushing electronic filing. Is that an option here?
Yes, absolutely. There's the terminal disclaimer system, for instance, which can streamline the process quite a bit, but you still need to meet all the substantive requirements, especially regarding ownership.
Okay. Now, are there things you can't do with disclaimers? Any major limitations?
Oh, definitely. One big one we touched on is you can't disclaim fragments of claims, only whole claims. Another critical one is that conditional disclaimers are a no-go.
Conditional? What do you mean?
Like you can't file something saying, I disclaim claim 5 if the court finds it invalid, or I disclaim this term unless I win my appeal on PTA.
Ah, trying to hedge your bets.
Exactly. The USPTO won't accept that. The disclaimer has to be absolute and effective immediately upon filing. No contingencies based on future events. It's a present surrender of rights.
Makes sense. And what about the process when you're actually responding to that double patenting rejection? Is just filing the terminal disclaimer enough?
No, and that's a common mistake. You can't just file this disclaimer form and walk away.
So what else do you need?
You need to file it with a formal reply to the office action. In that reply, you specifically ask the examiner to reconsider the rejection in view of the filed disclaimer. You have to connect the dots for them and request action.
Okay, good procedural tip. Now let's touch on Section 4 in the MPP chapter, how these disclaimers interact with other things, particularly patent term adjustment, or PTA.
Right, PTA. That's the system where the USPTO adds time back onto a patent's term to compensate for certain delays during prosecution.
So how does a terminal disclaimer affect potential PTA?
This is another significant trade-off. If a patent is subject to a terminal disclaimer, it generally forfeits its eligibility for certain types of PTA. Specifically, the MPP mentions that under former rules for delays due to successful appeals, that kind of PTA couldn't be granted if a terminal disclaimer was in place.
So even if the USPTO caused delays that would normally grant you extra term via PTA, you lose that extra term if you filed a terminal disclaimer earlier.
That's often the consequence, yes. It goes back to that anti-extension policy. You agreed to cap the term via the disclaimer to overcome double patenting. The office isn't going to let you then effectively uncap it using PTA. You made a deal, essentially.
Wow. So the decision to file a terminal disclaimer has these long-lasting ripples, affecting not just ownership flexibility, but also the ultimate lifespan of the patent via PTA.
Absolutely. It's a tool that solves one problem but introduces other constraints you need to live with.
Okay, so wrapping this up, MPP 1490 lays out these two distinct disclaimer tools, statutory for deleting bad claims, terminal for managing term, mostly related to double patenting. There are ways to, as you said, perform emergency surgery or strategically refine patent rights, but they come with very specific rules and some pretty significant long-term consequences.
That's a good summary. They are precise legal instruments. Using them requires careful thought, especially the terminal disclaimer with that common ownership requirement. And maybe here's something for listeners to ponder. Given that tough common ownership rule for enforceability, how should that affect a company's thinking way upstream when they're deciding about R&D collaborations, joint ventures, or even just how they structure their internal IP holdings, knowing that years later, a terminal disclaimer might lock those assets together?
That's a really interesting strategic question, how today's filing choices dictate tomorrow's business options. Definitely food for thought. Before we go, we want to give a special thank you to Mike Shepard, the creative director who organized this entire audio series.
And finally, please keep this in mind. This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It is provided for general educational and informational purposes only, and is not legal advice or a substitute for formal instruction. For authoritative guidance, always consult the official MPEP, a qualified instructor, or a registered patent practitioner.
Thanks for tuning in. We'll catch you on the next deep dive.